Welcome. My name is Ken Vercammen. I'm an attorney from Edison, New Jersey, and I'm here to answer people's questions about wills, power of attorney, probate, living wills, estates. So I usually start with people often ask me, Kenny, why do I even need to have a will? Doesn't everything automatically go to my spouse? I goes, well, that's not really doing planning. That's just hoping that everyone lives a long time. But then you still have the issue of who gets things down the road. So if there's no will, or the will was not prepared or signed properly, it was one of those cheap things online. Number one, the process to distribute assets becomes much more complicated. It requires all the beneficiaries to sign a thing called a renunciation, saying we all agree that so-and-so is going to be the administrator of the estate, and then they have to have it notarized and pay a fee to have it filed with the surrogate's office. Well, that's where everyone agrees. Sometimes people don't agree, so then they have to file a complaint or to show cause. It costs more money. There's also a thing called the surety bond that has to be taken out. That costs another grand. If there's no will, the will wasn't signed right, state law determines who gets assets, not you. And more people are not leaving their money to their kids or their spouse, not because they don't care about them, but the spouse could have a debilitating illness that they wouldn't be able to enjoy the money. One of the kids could be like a spendthrift or have their own problems, or one of the kids could be like have more money. One of the ladies said, I'm leaving most of my assets to my one daughter, not because I don't love all my daughters, but daughter number one is married to Dr. Rosenberg, the plastic surgeon. Their second house on LBI costs more than everything that everyone else in our family owns. They have their own money. The second one's comfortable. The third one I'm leaving it to. She married a bum. He doesn't pay child support, doesn't pay alimony, and she needs it more than anyone else. So remember, it's your right to do with your money what you want. If someone wants to leave it to the Yellow Dog Society, hey, the dogs get it, right? But the most importantly, if you don't have proper planning, it often causes fights, arguments, sometimes lawsuits amongst families. So when people are grieving, they shouldn't have one more thing to aggravate. So think about who do you want to get your assets, who you don't want to get your assets. If there's minor grandchildren, minor children, who would get it? The surrogate office also says when they've done seminars with us, beware of online forms, because the problems they see is where people try to wing it themselves and they didn't do it right. So I had my first house and I tried to do my own electrical work because I thought it'd be easy. I almost burned down my house. So it's kind of like that. After COVID, the process became, really a lot more easy. Is that a word? A lot more easy? Well, because the old system used to be someone make an appointment, take a half a day off of work, drive to our office in Edison, and then originally they'd be like writing it up, I'd be writing stuff, or they'd be filling out a form by pen. And now we try to make it easy where, people can type up a form. What's your name? Who's executor one? Who's executor two? How you referred. We usually don't recommend joint executors. It usually creates more work for the family. And that means that two people got to sign every check, do everything together. And those are for people who agree. I've been involved with estates where there'd be two brothers, and one brother, they couldn't agree upon anything. Brother number one would say the sky is blue, the other one would say, no, it's gray, you're stupid, you've always been stupid. So there's usually one captain of ship, an executive one and an executive two. Next, believe it or not, New Jersey reduced some of their taxes. So there's no more New Jersey estate tax. There's no inheritance tax if it goes to spouse, children, grandchildren. There is a federal estate tax, but that only applies to all you people out here that have more than $12.5 million. Not too many people in Sayerville have that much. Right? We ask people on the form about what real estate they have, but I don't need to know what their accounts are. Just like basically a total. Then basically you're putting down who's getting your stuff. So it's your right to do with your assets what you want. Last year, one of our, a client goes, do I have to treat all my children equally? He goes, no, you can do whatever you want. And that's your right. And I go, what's your concern? She goes, well, one of my sons lives on the West Coast. We don't hear from him much. All right. Well, I'll ask you a question. Did you get a card or a call on Christmas, your birthday, or Mother's Day? She goes, no. He goes, why would you leave this bum 2 cents? Leave him nothing. Let's see. Because listen, that one is going to be the biggest pain. The day after you die, that one's going to be like, where's my money? I want my money now. Nothing. And we don't leave him $1. There's no reason. Nothing to X. That's your right. The only person you can't make penniless is a spouse. Other than that, and more people are saying, listen, my kids already have their house. They're already comfortable. I'd rather live it for their my grandkids, because my own kids haven't put away anything for them. And I was the same way. My wife was a smart one. My wife was safe. And one year I went to this college, University of Scranton. I love Scranton. My friends are there. And one year I go to my wife, I'm gonna contribute $2,000 this year to the Scranton alumni. My wife goes, yeah, how much have you put away for your own kids? Nothing. You're gonna give $2,000 to a stranger, and you haven't put, well, since you put it that way, it looks like Scranton's not gonna be getting $2,000 this year. We'll put it towards our own kids. And in your will, you always want to have, if one person passes, who gets their share? You don't want to have anything dangling where, it has to be determined by a judge and the family has to go to court. So, in the old TV show, Leave It to Beaver, everything goes to the wife and then to the kids, and then when the kids dies, it goes to the grandkids. However, in the old Brady Bunch, it was a blended family, and I tell people, listen, let's say, instead of having you go outright to your new wife and then to all the kids, you wanted to go into a trust for that wife, and that way to the kids. And the guy goes, why? Why should I just give it outright to her? I go, because the day after you die, she can give it to her new spouse. Oh, well, we weren't planning on getting married afterwards. Because, well, you weren't planning on being here either. And I'm not anti-marriage, but believe it or not, if you, for the seniors, I sometimes say, if you get married on a Friday night, Friday afternoon for the seniors, because they got they don't stay up that late. I'd say, and then your new spouse has a stroke and has to go into a nursing home. After the new spouse runs out of money, you're on the hook for all that, aside from certain amounts you can keep. So it goes, why is it? Well, that's a federal law. So when sometimes I tell I remind some of the older people. So, but again, it's your right to do with your stuff what you want. Now, some people have what's called specific bequests. Some people leave some money to, their charity, or they might say $10,000 to each of my grandkids, or sometimes the lady said I want the jeweler to go to my granddaughter, my daughter. Some of the guys say I want this item of mine to go to my son or my nephew. So that's what a specific bequest is. Some people say, listen, I want $10,000, $5,000, $1,000 to go to my church. Okay, it's whatever people want. And I've already been through the reverse specific bequest. I leave nothing to bum. And people goes, can they contest it? He goes, well, contesting costs money. You got to file a complaint, order show cause, go in front of, spend money. And I say, listen, I've gotten calls by people that want to contest wills. I wasn't left anything by my dad. Okay, the judge is going to ask you 3 questions at some point. How many times did you see your dad in the past 2 years? We had a falling out. Okay, you didn't see him in all 2 years. No. Okay. How many times did you call him? We had a falling out, so we didn't talk. Okay. How many times did you try to communicate to him? None. Sir, don't waste your money. I mean, the judge is going to say, no wonder why, you wrote out, you were written out. Now if there's minor children, we told people they gotta have if you wanna have a guardian 1, a guardian 2, it's kinda, I told people they don't have to live in the United States, but it's kind of a just in case. Your will that you sign now is good the day you sign it. It's good 5 years from then, and it's good 20 years later. The only real question is, sometimes I ask people, is it still, can your executor still do the job if you did it years ago? So when I say do the job, the executor kind of has to go to the surrogate's office, and then they got to go to a bank and open up an estate account. Can they drive and can they walk up a flight of steps? If they're so old or sick they can't do that, maybe you can think of someone else that would be able to do that. If you don't have a will already, get one done. Not that complicated. A lady had emailed us the form on November. We emailed her the questionnaire. She filled it out the next day, and that was November the 13th, and we signed today. Because I kind of know. People sometimes say, I want to come and sit down. I go, all right, Mr. Shah, you're married, right? Yeah. Are you disowning your wife, or you wanted to go to her? I wanted to go to her. Okay. You got kids? Any of them minors? No. Okay. Are you disowning any of your kids? Or you treat them equally? I know what you need. So don't be a Carl. Carl was this retired engineer. And those engineer types where they would get, when they got a new car, they got the book, they would read the book from cover to cover. Carl kept on saying, I want to read up on this stuff. I go, Carl, you don't need to read up on anything. I went to law school, I passed the bar, I go to seminars all the time. I give the seminars, I wrote a book on this. You don't need to read anything. I said, just like when I need a knee surgery, I didn't read books or study about knee surgery. I called Rutgers track coach, hey, who's the best guy you got for knees this year? And I joked with the doctor, have you done this before? Yes. Now, okay, good. Anyway, after, Carl wanted to read up more. 2 years later, Carl's daughter, I called because she found, one of these in the house, and she asked me if I had his will. I goes, no, Carl wanted to read up more on the stuff, and he never paid us to do anything. So, and that kind of screwed them, because when there's no will, they're spending thousands and thousands of dollars more. So, if you don't have documents, you're kind of screwing your family. It's like if there was a leak in your basement, and you're saying to yourself, I just hope it goes away, and then you die, and your family's getting a house that's filled with mold, and the basement got to be remediated, etc. After you sign your will, you can, only the original will can be admitted to probate. If you already have a will, you got to make sure Executor 1, Executor 2 know where it's at. If you can't find the original will, have a new one done, because think of the surrogate as a fancy name and a way for the will clerk. If you have the original will, check for $160, $70 and a death certificate. Surrogate can admit the original will to probate. But a photocopy got to go in front of a superior court judge. Yeah. That's a little bit about wills. Before I go on to the next topic of trust, does anyone have any questions on wills? No? Okay. My mother-in-law used to call me up every other year. I want to come in and get a trust done. I want to get a trust. And I would say, were you watching Susie Orman on TV? And she'd say, oh yes. Oh yes. I go, Susie Orman is so correct. If you live in New York, California, Florida, where probate is very complicated and very difficult. But New Jersey probate is relatively easy. Most estates get done where it's going directly to family within 5 or 6 months. So I usually ask people, why do you think you need to spend between $3,000 and $6,000 having a trust prepared and then transferring your assets into the trust? It's not just doing the document; it's not owning the assets anymore and transferring them over. Now, if someone lives in New York, California, or Florida, and they have real estate there, if they don't have the assets owned by a trust, they've kind of screwed their family, because the process in Florida takes 3 years. It costs $15,000 in the simplest estate. New Jersey, though, most people don't need to put their assets into a revocable trust. Now, there's another kind. Now, for people with minor children, sometimes we'll have a trust within the will called a testamentary trust. What the testamentary trust says, hey, if I die, then certain monies go to this child or this grandchild, but I'm not transferring the money in until it doesn't go until after I pass. Sometimes those people have adult children that they have issues. They could be an alcoholic, they could have substance abuse problems. So we can have a testamentary trust for an adult child within the will. Now, a different kind of trust, a revocable trust, people do that. They're concerned about going into a nursing home, Medicaid, that kind of thing. So, that means that the trust is prepared, the assets are transferred, the house, the other accounts. You don't own it anymore. You can't be the trustee, and you can't get it back. And sometimes the downside of doing that is that if then there's a falling out between you and the trustee, they can say, hey, screw you. I'm not providing for you. People a lot of times ask me, hey, what would I do, or what did I do? I goes, let's see, why would I want to qualify? Medicaid is welfare. If you want the government to pay for your nursing home or someone else's nursing home, they got to be penniless. Just about, they can't have more than, I think it's $2,000. So someone said, what would I do? He goes, what? And there's really not, some nursing homes that are very nice, clean, new, good staff, are the ones that are not as nice and not as new. I would say, do I want to go into the nice one or the not nice one? Me. Why should my son, Dr. Brendan, the dentist, have a bigger boat? I want to go to the most expensive one that exists. If there's any money left over, they get it. But, I remember years ago before, you guys remember before there was a thing called cell phones, and how to use maps and figure out how to get, how do we exist? So, my club, we were doing a 10-mile running race in Freehold. And I took out the Exxon map and how to get there. I goes, oh, where my grandmother's at the nursing home, she just moved to go. She was like 95 years old. It's not that far. So I told my wife, I'm going to get a ride from one of the guys on my team, and then a ride back, off of Route 9, the nursing homes there. It's called Fountain View. Why don't you bring it'd be our kids, the great grandkids, to come down and see their grandma. It might be the last time when you're 95 years old. She says, okay. Well, she's driving down Route 9, pulls in the parking lot of a nursing home, goes to the front desk, goes, hi, and she goes, she looks around, this place smells. I feel so bad. Ken's grandmother, 2 years ago, she was making us dinner. My wife says. Then she asks at the front desk, I'm here to see Virginia Vercammen. Someone looks up, nah, not here. I said, oh my God, they lost Ken's grandmother. What, she roaming the streets down Route 9? She goes, no, I'm supposed to, I'm supposed to meet him here, like Route 9 Fountain View. Oh, no, this isn't Fountain View. This is Smelly Views. Fountain View's down the road. Fountain View is very nice. Smelly View, not so nice. So that's my little bit on Medicaid and trusts. Okay, next let's talk about the power of attorney. The power of attorney transfers your assets if you, while you're alive, or it really doesn't really transfer anything. You're giving the power to someone to be able to act on your behalf. I'd say, so you're not giving up your rights. You're just saying, hey, listen, I'm picking someone to be able to help me out financially if it's needed. Okay? The important thing about a power of attorney, sometimes for a lot of people, the power of attorney is more important. I'd say, because for most people, okay, if they died, they had 3 kids, no spouse, under law, it goes to the kids. It costs more money. But if someone had got a stroke or a heart attack and they're incapacitated, if there's no power of attorney, then they gotta wait. It would take 2 months, it costs $4,000 to go through a guardianship and have someone appointed as a guardian. We get a call every week. I need to get power over mom, dad, or my brother. We get a call, oh, my dad's in the hospital, I need to get a power of attorney. Well, unfortunately, you can't get power of attorney over anyone. They have to affirmatively give it to you. Now, we've worked with people where, their family members in a hospital or a care facility, but, I say, listen, are they competent now? And can they talk to us over the phone? If that, and some people aren't that good on computers or in the hospital. Listen, let's say, you can help them out. You can type up our short form, who's agent 1, who's agent 2. But before we do, I need to talk to them, and they got to say who they want. They can't just say, whatever my daughter wants is good. So the whole idea is you get it done now rather than not, over the weekend. Another call. I need a power of attorney for my dad. Can't do it. He has to call us up and do it. Now, the power of attorney is either effective right away or only upon disability. We usually recommend it be effective right away, because otherwise the banks give you a hard time if it's effective only upon disability. Well, we need to know from a doctor. Well, maybe the person got better. I don't know. Some of the banks were giving people a hard time because they would say, oh, it wasn't done on, again, a lot of the big banks are now controlled by people out of state. It wasn't done on our form, so New Jersey came out with a statute that the banks doing business here got to recognize as long as there's reference to New Jersey statute. But the statute was Section 2 of PL 1991, C95, C46 called 2B-11, and we're pretty sure those cheap things online don't have that. Power of attorney, as I said, if it's effective right away, it's durable power of attorney stays in effect even if you become disabled. If it's effective only upon disability, that's called a springing power of attorney. Only springs into effect if you become disabled. One of my clients, he goes, Kenny, I don't understand legal stuff. He goes, dude, I'm a carpenter. I hammer nails outside. Explain to me in carpenter language. Okay, you said you want your son to be the person. If it's effective right away, your son could steal all your money right away. If it's effective only upon disability, he got to get a note before he steals all your money. Knowing that, you trust your son. He goes, oh, I trust my son with my life. Good, make it effective right away. No need to put off the inevitable. Where should the will be kept? In the other documents, buy a fireproof box and close it, put it under the bed. Make sure it's closed though, because if there's a bunch of paper sticking out, then it's not fireproof. I saw when we were living in South Brunswick for a while, my wife's fireproof box had so many papers in it that it was sticking open, and half of it was junk. It was like envelopes or things. He goes, put the important, and no one's gonna steal it. You gotta hide the good stuff, in a box and put it in the freezer. That's with jewelry, but no one's gonna fireproof box. No one wants to take papers. All right. That's on power of attorney. Does anyone have any questions on power of attorney? Okay.
Ken, excuse me.
Yes, sir.
The power of attorney, it's a standard form, so it's only one
no,
form?
it's not a standard form. I mean, different attorneys have their different ways of doing it.
But it's recognized through whatever financial institution in the state.
Now, what I've been recommending to all our clients now is, because the banks can't say, oh, it wasn't done in our Wells Fargo form, right? Mm-hmm. But what a good idea is to, after it's signed, scan it, email it to yourself, email it to number 1, email it to number 2, and email it to anyone that, your financial advisor. Email it to your accountant, anyone that kind of deals with your money. With the will, only the original will can be admitted to probate, but we still tell, because we're trying to be environmentally friendly and paperless, scan the will, you email it to yourself, email it to executive 1, executive 2, and then you say, hey, listen, the original is located at wherever you're going to keep it. Don't keep it in a safe deposit box. You can't get to a safe deposit box when you need to. That's it. Just like why keep a power of attorney in a safe deposit box? All of a sudden it's needed on the weekend. You can't knock on the door of the bank and say, open up. You know, that's why a fireproof box is better.
Do people keep the will at their attorney's?
That's a good question. Do people keep the will at the attorney's office? The Supreme Court said that's kind of a no-no, because here's what was happening. Attorneys were saying, oh, I'm keeping the will for you for safekeeping. But then the attorney would die or they would retire. Where's the original will? So the only time we keep the original will is if we are the executor. And why would we be the executor? Some people say, listen, I don't have any relatives in New Jersey. I'd say, or I'm giving my money to a charity. No charity will be the executor. Will you be the executor? But the person has to affirmatively say, I want the attorney as the executor, because what was also happening is the attorneys were inserting themselves as the executor. I put my trusted attorney, like Ron Leibowitz, and probably never, aside from getting a referral of that attorney, didn't know who he was. So if we're going to be the executor, where someone has, they're leaving it to charity, otherwise, it's the person. Now, sometimes if someone's not married, they may have the will kept by the executor rather than them keeping it. What is if there's an unequal distribution, make sure that the will is in a spot where it can't be destroyed by the person who's not getting their fair share, but all of a sudden they find the original will and goes, bullshit, I'm being screwed. What? No more will. So, did that answer your question?
Yes.
Okay. All right. The last document we're going to talk about, because went more than, I usually only go about 30 minutes, is the Living Will Advance Directive. What the Living Will Advance Directive is, you're giving instructions to hospitals and doctors. If you can no longer talk, you're in a coma or irreversible condition, some kind of terminal condition, and you're basically giving instructions to hospitals and doctors. Say, listen, I don't want to be on feeding tubes. I don't want to be on respirators. If there's no hope for me, in a way, kind of pull the plug. The document is very important because it's really not a document for you if you're a sick one. It's so that you're not putting people you care about, that they have to make that decision. Because, it's a hard. I remember one time when a doctor asked me, when a person did not have a living will. I was a power of attorney, but okay, should we remove life support today? Geez, doctor, I feel bad. You know what the right decision is for someone who's 92 years old that's not going to open up their eyes again, but you hate to be the person to say, yeah, go ahead and do it. You feel bad. It's like, when my first dog was so sick, and it was at the end, and the doctor goes, I can't do anything. We already spent $16,000 at the Red Bank, vet hospital. And, finally, when it was the day, I told my wife, listen, you got to bring the dog in, because I won't do it. I'll bring the dog back home. So, now, with your living will, your fluids and nutrition, yes or no. Artificial machines, yes or no. And 99% of people say, listen, I don't want to be kept alive. Then we included some language from what the Medical Society has, New Jersey Medical Society, and also a clause for organ donation, yes, organ donation, no, which typically we try to recommend. After the living will is signed, we recommend people scan that, email it to each other, number one, number two, and to the primary doctor. The last thing I'm going to talk about is probate in New Jersey. Now, by the way, I talked about wills. Well, certain assets don't pass under the will. So if it's payable upon death, joint account, whatever, the will can't change that. So if Mr. X says, listen, I want my money's to, I want a new will, I want it to go to just this one person. I goes, you got to make sure that your investment accounts are changed, because whatever was previously put down, that controls. The will does not override what you put down as that. You know, when it's a household husband and wife, it automatically goes to the survivor. You know, if it's payable upon death, it automatically goes to the survivor. And Dan, who's a financial advisor, might briefly touch upon that. We always have a clause in the will that says if it's going to someone under 21, it should be held until they're either 21 or 30. So when people have minor children, we say, hey, they get someone, typically on our clause, they get some when they're 22, some when they're 25, the balance when they're 30. But as much money as is needed can be expended for education, support, etc. But otherwise, you don't want 18-year-olds to get money because I don't know about you, if I would have got a chunk of money when I was 19 years old, I wouldn't have worked 55 hours a week because I always worked. And then, you know, when people talk to me about, you know, why would I want to spend all of my money on nursing home? I goes, because I worked for it. He says, I always worked. You know, I was so happy when it snowed because I could make some money shoveling. Let's see, I was a paper boy delivering newspapers in the rain, so I always worked hard. You know, so you know we've made it so that people can do as much as possible remote. You still got a paper, you still got an ink signer. The will got to be signed in front of the self-proving will person, 2 witnesses, and then the notary. But after that, probate, New Jersey's pretty easy. Other states, New Jersey, much more complicated. New Jersey is the easiest state. And with that, Dan, can you turn that off for a second? Sure. You know, what we, you know, probate New Jersey, you know, the certificate, original will, death certificate, check.